We need one more. Okay, we have everyone. No one appears to be muted. Ms. Gaffney, you have the floor. Did you wish to reserve any time for rebuttal?
Yes, Your Honor. We'd like to reserve 5 minutes for rebuttal purposes.
Okay, I have it down, and I will try to promptly let you know when you arrive at that point in your presentation.
Thank you. We appreciate that. I am Terry Gaffney, and I am the attorney for the appellants, and we do want to thank the court for the time and allowing us to have our oral arguments today. For the reasons laid out in our brief, we believe that the lower court order should be vacated because it's void and it's void ab initio. And after the lower court judgment was entered, there was additional evidence that showed that there was a denial of due process, and witnesses who evidence that was found, there were witnesses who should have testified, and we believe that there was a due process violation. The judgment was void because there was never subject matter jurisdiction over the homestead property, and it was entered in violation of due process because there were witnesses who needed to be called. Relief was granted, which was not supported by the complaint, and relief was granted in excess of what was requested. The underlying lawsuit was meritless and had no basis in law and fact and should have been dismissed. And the appellees, the plaintiffs in the lower case, relied on a sanctions order that alleged contumacious behavior by the appellants. For reasons laid out in the brief and the reply brief, there was no contumacious behavior, and there were witnesses who were able to testify who were not allowed to testify, who would discuss the irregularities of the sanctions order. And for those reasons, the appellants were always denied their due process. But more importantly, under Article 10, Section 4 of the Florida Constitution, homestead property was taken, and Article 10, Section 4 of the Constitution does not allow homestead property to be taken. And to not vacate the lower court judgment would to flip and invalidate Article 10, Section 4. Mr. Kangas wants to say that the Article 10, Section 4, Ms. Sussman never had homestead property, and as the deed was invalidated under 415-1111, it wasn't her homestead property. Well, that's not the law. And the fact he cites N. Ray Alexander, a bankruptcy case for that proposition, and N. Ray Alexander talks about how a revocable living trust is entitled to homestead protection. But the homestead protection is outlined in Middle District Court case Pasternak versus Klein, and Judge Virginia Covington does an excellent job of explaining that if it's your homestead property on the day of the recordation of the judgment, you're entitled to all the protections of homestead. And Article 10, Section 4 of the Florida Constitution does not allow homestead property to be taken. And in this case, Judge Barbas admitted after the final judgment that it was taken as a sanction for the homestead property of Sarah Sussman was taken as a sanction against the other appellant for discovery order violations, and yet there were no discovery order violations that Judge Barbas issued. And because of that, you can't take homestead property as a sanction. It's not permitted. I didn't know if somebody, okay. And it's not permitted under the Florida Constitution. So you can't take homestead property, and it was taken. The other argument is under 415-1111. And in the complaint, they allege exploitation of the elderly, and they attack the appellants and say they exploited Mr. Gaffney. And that's not the case. In fact, if witnesses had ever been allowed to testify, they would have found that the exploitation was not by the appellants, but rather the clients, the appellees, the disinherited daughters of Mr. Gaffney. In fact, if you look starting on page, I believe, 395 of the appendix, you will see affidavit after affidavit and testimony saying that the appellants actually helped Mr. Gaffney. They purchased his homestead property, allowed him to live there, and he had been impoverished, not by the appellants, but by the appellees. And that would have been the testimony of the witnesses who were never allowed to testify. Further, we have a duty under 415-1111 to follow the strict construction of 415-1111. And under Florida Statute 415-1111, exploitation of the elderly can only be brought by a certain number of people while the exploited individual was alive, and only by the personal representative when the exploited individual is dead. And the personal representative never never explored that because there was never any exploitation of the elderly. Mr. Kangas did not have standing to bring this action under 415-1111, and the court never had the jurisdictional authority to grant any kind of relief under 415-1111. And the denial of allowing witnesses to testify, saying that there was no exploitation, was a denial of due process. Exploitation of the elderly is a quasi-criminal crime, and to accuse an attorney of exploiting her father without evidence, in fact, when the weight of the evidence shows that she actually supported him because he was impoverished by the clients of Mr. Bowman. In fact, before his passing, Mr. Gaffney actually did an affidavit in which he stated that Mr. Bowman's clients had financially exploited him. That's powerful testimony that was never allowed in, but was filed within the court. And that testimony is relevant because that's a due process violation. And Mr. Kangas is saying because they had a default judgment entered on a spurious sanctions order, that they got to that their pleadings must be accepted as true, and that is not true. Just because you get a default judgment doesn't mean that your complaint has to be taken as true, because there's been a sea change. Textualism is what gives consistency in the law, and because the 415-1111 states that only a rep and not administrator litem can bring an action, there was no relief that could have been granted. Number two, there was no evidence of exploitation, or there has to be exploitation. And the third thing is, how does this lawsuit benefit Mr. Gaffney? Throughout the course of Mr. Gaffney's life, and after the discovery of the theft of the property by the clients of Mr. Bowman, the appellants took care of Mr. Gaffney. They purchased the homestead property in 2009 so that he had a place to live. That's the weight of the evidence. That's what the witnesses, and we have affidavits from attorney J. Kevin Carey, who is Mr. Gaffney's personal attorney. And that was the reason the home was purchased, to give him a place to live. And to make sure he felt secure, it was given as a life estate. So he knew that the home could never be taken from him and that he could die in his home. The roof was replaced, toilets replaced, mildew was taken out. All of that was done so he could have a comfortable life. And if the affidavits and the evidence had been allowed to be presented, it would have shown that evidence came from, that money was paid for by the appellants. There was no exploitation. Mr. Gaffney was impoverished. That would be the testimony starting on page 399 of his other attorney, Lisa Hatamoto, which says that Mr. Bowman and his clients had impoverished Mr. Gaffney. And so the appellants stepped up to the plate and helped him out. And now they're being falsely accused of exploitation, and no evidence is allowed to be permitted to be entered. That's a due process violation. And because it's quasi-criminal, it's an incredible burden that they had to meet, and the appellants were entitled to have witnesses present. The other part of that is, who did this benefit? Mr. Kangas took the homestead property that was paid for by the appellants and now is asking for hundreds of thousands of dollars of fees. So the other creditors don't get the benefit of anything. So how does this help Mr. Gaffney? That is one of the elements 415-1111. It has to benefit the exploited person. And the appellants did that. They benefited him. They took care of him, and they paid for him. And that would have been the testimony of all the people. And I believe we laid it out in the initial brief of the people and what they would have testified to, but they were never allowed to testify. And that denies due process. And the benefit was by Mr. Gaffney was by the appellant and not the appellees. And under 415-1111, the court never had the jurisdictional authority to even grant such relief. And so they could not grant relief under it. And Mr. Kangas says that that's the relief granted throughout the whole complaint. Well, if that's so, there was no relief that could be granted. So the court, in allowing relief to be granted under a statute that the court had no jurisdiction to allow relief, is a violation of the due process of law, which renders the order void. The lawsuit was filed without merit. There was no basis in law and fact. In fact, they were going after the homestead property, which When it was purchased by the appellants from Mr. Gaffney, it was given as a life estate deed. And the life estate deed was done so that he had, as I said before, the security to know that he had a place to live in for the rest of his life. When he died, a life estate deed doesn't go into the assets of the estate. In fact, it passes outside of probate. And this court said that in Bourne versus SunTrust, that a life estate deed doesn't pass within the estate. When there was an order of the probate court to obtain assets of the estate, those are the words, it didn't say actively pursue the property purchased by the appellants, it said assets of the estate. You have to really go back to Mr. Gaffney's will, which is in the appendix at page 404. And Mr. Gaffney's will is very specific as to what the assets of the estate are. And he specifically says in his will, the assets taken by Mary Alice Tyler, who is his disinherited daughter and the client of Mr. Bowman. And I think that's also powerful testimony that the assets of the estate were really the assets of the appellee's clients. And that testimony was never allowed to go in. And therefore, that is why there was no subject matter jurisdiction, because the homestead property, the probate court never had any in-rem jurisdiction. And because it didn't have in-rem jurisdiction over the property, it couldn't transfer jurisdiction that it did not have. And that comes out of Spitzer versus Banning. It's a nice old 1938 case, which says if the probate court doesn't have in-rem jurisdiction, it has no authority over the case. And that case was actually upheld a few months ago in Warner versus Quicken Loans that talks about a probate court having in-rem jurisdiction. And the other part about that is, and as I said, that a life estate is never it can never be an asset of the estate. The other part about that is the case was meritless because it was filed on its face beyond the statute of limitations. They had no standing, and the property of the estate was not the homestead property taken, but rather was the monies taken by the clients of Mr. Bowman. And therefore, the court never had subject matter jurisdiction. The court also granted relief in excess of the pleadings. And how that did that is the pleadings never asked to invalidate the deed, nor the invalidate the deed of Sarah Sussman, but they did. And they did it under 415-1111. And under 415-1111, they wouldn't have had the standing, nor could the court have granted relief under that statute. And therefore, without being able to grant relief, it could never have invalidated the deed. And the deed was, they never asked to invalidate the deed. Because they didn't ask to invalidate the deed, the trial court granted relief not requested in the pleadings. And again, you have to have well-pled pleadings, and you have to have a basis and a ground. Miss Sussman was never accused of exploitation, yet they took the property under 415-1111. Therefore, she was denied due process, and the court never had the jurisdictional authority to grant such relief. The transfer of the property, again, passed outside of probate and therefore could never have been an asset of the estate. Now, Mr. Kangas likes to say that there was a default judgment. And a default judgment, again, you don't get to reward if there was never a complaint. We're not going to go into to those issues, but if there is a default judgment, you don't get to be rewarded for a merit and for a complaint that doesn't have any merit, nor do you get to be rewarded for your bad behavior. Mr. Gaffney was not impoverished by the appellants. Mr. Gaffney, if we look at the evidence that was presented to the court but never allowed to be heard, was that the appellees and their clients impoverished Mr. Gaffney, and that comes from the testimony of Mr. Gaffney's attorneys and through affidavits and even a creditor. In fact, one of the creditors, the check was supposed to go to the creditor, but the monies were actually paid to Mary Alice Tyler's, and they paid off her credit cards. And that's in page 404 of the appendix, where Lisa Hatamoto explains that monies were taken out of Mr. Gaffney's account by the appellee's clients without Mr. Gaffney's authority or approval. So the theme that ran throughout this whole complaint was the appellants were bad, and they never had an opportunity to ever sit there and present their side. And that denies one due process. And the court has to have the jurisdictional authority to render such a judgment. For the court not to vacate the lower court would be in violation of Article 10, Section 4 of the Florida Constitution. It would invalidate it. Homestead protection is great, and the protection, the appellants are entitled to that protection. This court recently in Anderson versus, I couldn't tell if you were asking a question, in Anderson versus Lebowski, stated that we liberally construe homestead protection and it's secured. And the other part about it is under the text list and rule we're a nation of laws, men 415-1111 never gave the authority of the lower court to ever entertain this case.
You are at your 15 minutes.
Oh, okay.
Did you wish to reserve the balance of your time?
Yes, sir, I do. And I would like to say, for those reasons, we'd like the order to be vacated. Thank you.
Thank you. Hold on a moment while I adjust the clock here. Okay. Mr. Kangas, the floor is yours, counsel.
Yes, may it please the court. Michael Kangas on behalf of the appellee, Philip Bauman, as the administrator ad litem of the estate of John Gaffney. I sit here today in a very familiar situation. It seems like deja vu almost, except for we're not in the courthouse and there's a different panel of judges. But every argument that was just made by Ms. Gaffney was made as to the final judgment that was entered 4 years ago on the prior plenary appeal when we argued this on February 3rd, 2019 before this court. This is an appeal of an order denying relief from judgment under Rule 1.540. It's not a review of the prior orders that have already been affirmed. And this court must dismiss this appeal or affirm it. Number one, because all of the reasons raised were not authorized because they'd been previously raised, or they weren't timely. And it's not a void judgment. With respect to the argument about subject matter jurisdiction, standing, statute of limitations, all of those issues were previously fully briefed, argued, and ruled upon by this court. There's no question that these things have already been ruled upon. The same cases are relied upon today. The one thing that was raised in this motion is this due process, and I want to touch on that because everything else is pretty much the same. But Ms. Gaffney, or the appellants argue today that they were denied due process to present evidence, and that is untrue. The case was filed in April of 2014 and came to a conclusion by final judgment dated October 16th, 2017. Over that 2.5-year period of time, Ms. Gaffney and Ms. Sussman, the appellants, had a full opportunity to participate. Unfortunately, for them, they decided, and wrongfully so, to thumb their nose at the court and not show up because they didn't think there was any merit to the case. But because they did not appear for deposition, sanctions were entered against them. A hearing was held on March 29th, 2016 that they didn't appear to. And after taking evidence, a 22-page order was entered on April 22nd, 2016, striking their pleadings, but not entering a default yet. In that order, they were given an opportunity to show up for another deposition. They didn't do so. And at that point, a default was entered and a final default judgment was entered. But after the pleadings are stricken and a default is entered, they've lost their right to defend until they can overcome that default. And because that default was affirmed in the prior appeal, there is no violation of due process, and there's no new argument today or in the motion that brings rise to a void judgment. I'm under the weather this morning. I don't want to continue to belabor this, and I respect the court's time. If the court, other than what I've addressed, if the court has any specific inquiries, I'd be happy to address those. Otherwise, I'd yield the rest of my time back.
Checking the video, I don't note any questions. Then we'll allow you to navigate your weather condition, and we'll proceed to the rebuttal.
Thank you, Your Honors.
Let me check to the clock first. I have to multitask, and I lack skills in technology. Counsel, Ms. Gaffney, you may proceed.
A void order never gets better with time. A void order is always void. And Mr. Kangas wants to go back to his sanctions order. And the due process was, unfortunately, and if you look at page 44 of the appendix, Judge Paul Huey and Michael Kangas met on January 19, 2016 at 2:00 in the afternoon and discussed this case. Witnesses came forward after the final judgment the last time and testified as to the substantial nature of the conversation. The meeting actually, it was in an effort to put together the sanctions order. What Mr. Kangas doesn't tell you is the fact that depositions were taken, my deposition was taken, and that due process was denied the defendants. This case was meritless. It was filed without any basis in law and fact. And the other fact is, how is this benefiting Mr. Gaffney? And it doesn't. And because the fact that the sanctions order is a product of ex parte communications, this court, the Florida Supreme Court, and all the district courts of appeal say ex parte communications are the greatest denial of due process. They're a black mark on the integrity of the judicial system. And therefore, the ex parte communications, which witnesses wanted to testify to as to the substantial conversations and the nature of it and the admissions against interest, we were denied such a request. And everyone in this judiciary wants to make sure that we have a fair judiciary without bias. And the clearest case of bias is having ex parte communications. The court cannot do anything but vacate this judgment because it turns Article 10, Section 4 of the Florida Constitution on its head.
The hearing that you wish to bring forth a testimony regarding ex parte communications, was that the hearing to set aside the judgment?
No, sir, it wasn't. In fact,
So was it a hearing prior to the entry of the default judgment or the sanction judgment, the one that followed there? I'm looking for the timeline. As I went through all the appendix, I kind of got, a little bit lost in the grass. I'm hoping that you can help me out here.
Okay, I can help you out quite well.
This would have been before the final judgment?
Yes, sir. It was in January, January 19, 2016 at 2 p.m. And it was in a separate case. It actually was in case number 13-CA-009542.
Okay.
That is not the case. That is not the case that we're in front of.
Not this case.
Not this case, sir.
Right.
What had happened.
Was that the case your depo was taken in also, or was your deposition taken in this case?
It was taken in this case.
And was it taken after the final judgment or prior to the final judgment?
6 months prior to the final, 6 months prior to the sanctions order, sir.
Okay.
And what
I want to make sure that each one I'm reading, I put them in the right timeline.
Yeah, it's kind of confusing. But in this case, because the ex parte communications case happened in a case called 13-CA-009542. The appellants in this case were never part of that case. It has nothing to do with the appellants. So there was, if you look at page 44 of the appendix, there's a notice and a motion and an order. The notice and the motion and the order reference the lower court case here, which is 14-CA-3762. The appellants, by the admission of Mr. Kangas, were never noticed as to the fact that they were going to discuss this case in a hearing. And they discussed the case in a hearing. And our witnesses to the admission against interest who came forward and wanted to testify as to the discussions they had were never allowed to testify. That is a due process violation. And that came in after we found out after the judgment, the fact of what happened and what occurred. Mr. Kangas has admitted that they discussed the case on July 12, 2019, because he said discussing a case is not the same thing as talking about the case. But the canons of ethics are very clear. And Article 3 of the Canons of Ethics say that if there are ex parte communications, all you have to do— I
don't want to take you off on a thing about ethics because you're running out of time. Only about half a minute left. So I don't want—
Okay.
If you had another point you wanted to make, I want to make sure you got there before time got called.
Well, but that is a due process violation. And in fact, it's an incredible due process violation. And the other part about that is 415-1111. They never had standing to bring the action. So the case, so the case could never have proceeded forward. It was meritless. And the other part about that is Article 10, Section 4 of the Constitution does not allow homestead property to be taken as a sanction. And this court said in Anderson versus Ladowski about 3 or 4 months ago, homestead protection is liberally construed.
I think I know that opinion.
Did you write it?
It's possible.
Sorry, it's just, but 415-1111 there was no exploitation, and they don't get the benefit of the fact they actually impoverished Mr. Gaffney, and testimony needed to be presented. Due process rights are Article 1, Section 9 of the Florida Constitution are sacrosanct, and you cannot deny people due process rights. And Mr. Kang is not true. There was a motion for summary judgment that was pending from September 2015. That was months before any sanctions order. The courts refused to allow that to be heard. Due process was denied from day one. This was a meritless claim that should have been dismissed, and the order
And I
is
need to
void.
tell you that your time expired a bit ago.
Oh, well, thank
So,
you.
I want to
Thank
let you
you.
complete your thought. I thank you both. Please be safe in this world that we live in. And for those people that are listening, as promised before we started, the court is going to take a 10-minute recess. According to my clock, it's 10:42. So I'm sorry,